So we're going to focus today on how we might export the best elements of our U.S. system. I think the mic just came on, while leaving behind some of the harms that our system has caused, either through overly punitive or retributive practices, or through unintended consequences that have resulted in inequities in the U.S. So each of our panelists will share some insights on lessons we've learned across justice systems and from implementing rule of law or access to justice interventions abroad. And if we have time at the end, I stuck a little note in my notes that we could maybe also talk about models abroad that maybe have some application here in the U.S. So now I'd like to invite our panelists to come up to the stage and introduce yourselves, and then we'll start with our discussion. Okay, so let's start with you, Brent.
I'm Brent Newton. I retired earlier this year, from the United States Sentencing Commission. I was the deputy director for a decade. Prior to that, for 17 years, I was a public defender in both the federal and the state systems, handling cases ranging from small misdemeanors to the death penalty. I also, for 20 years, have been an adjunct professor both of law, political science, and briefly for a period of time of criminology as well. So I kind of have an academic as well as a practitioner as well as a policymaker's perspective on these issues.
Great, thanks, Brent.
Hi everyone, I'm John Salva. I am with the Center for Court Innovation. I work specifically at one of the center's demonstration projects in Brooklyn called Brooklyn Justice Initiatives. If you're not familiar with the center and some of the work that we do, we've been around since 1993. I've been with the center for about 9 years now, and we have created things like the Midtown Community Court, the Red Hook Community Justice Center, which I think some folks may be familiar with. But the idea for us is to try to make the justice system a more effective and humane place. And so we work very closely with city agencies and city service providers, as well as working with individuals on the ground. And so we are a mix of kind of research and translating that research into policy, but also implementing that through our demonstration projects. I oversee the demonstration project in Brooklyn, which exists within the criminal courthouse. We provide alternative to incarceration and alternative to detention services within the criminal courthouse in Brooklyn. And in the last year, we've serviced over 5,000 clients, have been able to take advantage of those services.
Good morning, my name is Jenny Murphy. I've been doing justice sector reform work. I'm getting an echo. I'm not sure if you guys are getting an echo. I've been doing justice sector reform work for over 20 years, either with USAID, with their Democracy and Governance Office, State INL, most recently with Creative Associates, and now I'm returning back to AID on June 1st to work on procurement reform in its application to DRG programming. So I'm actually technically on vacation and for the next month. But I have been involved with justice sector reform work globally, pretty much all over the world in all of those capacities in the last 20 years, but most specifically in Latin America. And I'm happy to be talking about this subject today in terms of international application of U.S. criminal justice reform.
And we are very grateful to have you here during your vacation. So as Chris mentioned, I'm Sarah Jalbert. I am a justice systems researcher at APT and have been for about 20 years. Primarily, my focus has been on outcomes in community supervision and corrections. I also lead our justice portfolio of work, in that I manage our portfolio of projects, which range from the research and evaluation projects that I work on to also some large-scale data collection projects that we run for various federal agencies here in the U.S. I am just learning about international rule of law. At this point, I think more so than in my career before now, that there is a lot of interest in overlapping systems of justice across the U.S. and models that can be replicated and implemented, whether abroad, U.S. models abroad, or as I mentioned earlier, maybe models from other countries that we should be thinking about in the U.S. So I'm really excited to be here and do some learning. And now I'm going to ask each of our panelists to give just a brief overview of some of the points that they'd like to make about this subject, and then we'll move into more of a Q&A session, and then we'll open it up for questions from those of you in the audience. And also, I'm told we have a pretty large online audience today. A lot of people have called in, so if there aren't too many questions from the audience, then we'll open it up to the webcast questions as well.
So I'll begin by, I think, qualifying any comment I'm going to make that it doesn't absolutely apply to every state. It doesn't apply to the federal system necessarily, because our country is different from virtually every other country in the world in that we have a true federalist system. We have 51 different sovereigns, the 50 states in DC, that are independent sovereigns, have their own criminal justice systems. We also have the overlapping federal system. And although it's supposed to be uniform, I can tell you from my work at the Sentencing Commission, it's not. It's really 94 different systems. There's 94 districts. So we've got over 100 distinct criminal justice systems in the United States. And then even within states, we have rural versus urban, and we have even differences among cities and states. So we have a tremendous diversity, which can be a good thing and a bad thing. Justice Brandeis of our Supreme Court 100 years ago commented that the states are the laboratories for democracy, and it's true in criminal justice development as well. So some of the comments I'm going to make apply to certain parts of our country, and certain comments don't. So with that caveat, I think my big point today is going to be that in terms of the rest of the world looking at the United States as a model, there are good things and there are bad things. I think the good things, probably more than any other, are we have a very robust adversarial system. Our right to counsel, I think, is better than probably any other place in the world in terms of the resources that we give for free attorneys, court-appointed attorneys. Certain places, the federal system in particular, I was a federal public defender for 13 years, incredibly well-funded system with very dedicated attorneys who do excellent work, in my opinion, much better than the retained bar does in the federal system. Not true in a lot of states. The adversarial system, I'm a big believer in it. Things like cross-examination of witnesses under oath. A lot of the countries in the world, don't do that. They offer dossiers by the procurator, and that's the justice the defendant gets. I don't believe in that. I think our system is very good in that sense. Although 95% of defendants plead guilty in our system, which takes away the adversarial system for them effectively. We have huge numbers of cases that plead guilty, which is a function of the number of cases that we bring. We have our over-incarceration, our over-prosecution and our over-incarceration numbers are staggering. We are 5 to 7 times higher in terms of the adult population of people being prosecuted and incarcerated in this country compared to our peer nations. We have roughly 23-24% of the world's incarcerated population, but we're about 4-point-something% of the world's population. So there's something way out of whack in that regard, and it wasn't true 40 or 50 years ago. So it's something that's only happened in this country. I don't think we're 5 times as bad as our peers, and I don't think we're 5 times worse than we were 40 or 50 years ago. Something explains it. And I think it's policymaking choices that explain it by and large, policymaking by prosecutors, policymaking by legislatures and sentencing commissions and so forth. So there are a lot of things to avoid modeling in terms of the United States. Avoid the retributive instincts. That's what we have fallen back on more than any other thing, is when somebody commits a crime, we're angry about it. We don't consider the other purposes of punishment. Primarily, we consider retribution. We don't consider, do we really need to incapacitate this person because they're dangerous? Do we need to rehabilitate this person? We don't consider those things primarily. We consider retribution. So that's one of the things I would suggest, is that any country that's building a new criminal justice system, think about what your underlying purposes are. And I would caution against retribution. It doesn't really work. And once people go through the justice system, they're only going to get worse. We don't rehabilitate effectively. We're beginning to experiment with certain things like cognitive behavioral therapy and so forth, but it's not working. Our recidivism rates are through the roof. The Bureau of Justice Statistics put out reports recently, and the Sentencing Commission put out reports recently, that show over half of the people recidivate. Something like 70 or 80% within 5 years in the state system. They get out of prison, they're right back. So it's not working. So good things about the United States, bad things about the United States. And then look within the diversity we have. There are certain programs in certain places that are quite good and that are working well and that are evidence-based. And there are other places that are a disaster. So pick and choose would be my larger takeaway.
I want to build off that, Brett, and kind of our mass incarceration issue here in the States. And what it has, interestingly enough, produced in a place like New York City is a hotbed of reforms and ideas on what can we do with this issue. Though some of you may be familiar that the famous Rikers Island jail complex it looks like potentially may be shut down, and there's a plan by the city to do that. The idea on how to do that rests largely on the ability to try these different programs, some of which Brett has alluded to. And so I want to kind of today just kind of talk about this idea of diversion, alternative to incarceration, alternative to detention programming, but also touch on some of the stuff that Brett mentioned as it relates to recidivism and different programming. And so what we've seen in a place like New York City is that we've been able to implement diversion at different stages of the process. And so we have the ability to use a risk assessment, for example, at an arraignment hearing to determine which types of misdemeanors and nonviolent felonies potentially could be diverted and not have to go to jail. We don't have to have those, as many of you in the room may know, those harmful effects of incarceration after the 48 hours. We can avoid that if we have a social service provider that can potentially divert someone and help them get back to court, which is what bail is designed to do. And so I think in the meantime, what we're seeing is that bail reform has become a hot button issue that folks are talking about, that folks want to do something about, but we still have cash bail in many states. And so this diversion is one example of what we can do on the ground. It is a massive task in a borough like Brooklyn. Just to give you the example, there are 2.8 million people that work there. The only way that we can provide these services is by staffing an arraignment court part from 9 a.m. to 1 a.m. 7 days a week. That's kind of the hours of operation for arraignments. And so I don't know how scalable that is to other countries, but from our perspective, it is an attempt at looking at how can we divert and what can we do with this population. And so just to continue the example of that program, what we're seeing is that most folks do want to engage in a voluntary service, even though they haven't been convicted of a crime. We're seeing that if most of those folks do access those services, we're seeing different outcomes with their cases. And so we are seeing slightly lower recidivism numbers for folks that do have the support that they need to get to and from court that's outside of what their defense attorney can give them or what their immediate family structure can give them. We kind of move further along in the process, and let's just assume that you survive arraignments and you maybe paid your bail or you were released on your own recognizance. You're now looking at potentially jail time, depending on what the crime was. And so we have an opportunity to divert at that stage as well. We provide alternative to incarceration services where we're using a risk but also a need assessment at this point. We're starting to figure out what is it that's going on and how can we address some of the needs that you have to hopefully reduce some of that recidivism. And so we are then in a position to help prescribe a service and help someone dispose of their what is going to happen with their case through a non-traditional mean, right? And so what we're seeing is you can take advantage of maybe a restorative justice program, maybe a cognitive behavioral therapy intervention type of program or an evidence-based program that helps you dispose of your criminal matter while also receiving supportive services in the community. And so those are kind of the two diversion points, but I want to kind of go back to the beginning in that arraignment process. And I think in cities like New York, what we're seeing is diversion before you come in contact with the criminal justice system. And so what do I mean by that? If you look at our traditional, and again, I will use the Brooklyn example throughout the conversation today, but if you look at places that are traditionally disadvantaged from a socioeconomic perspective, what we're seeing is that those folks coming from those neighborhoods have disproportionate contacts with police officers. And so what we're doing is trying to do more community work in those neighborhoods with youth to try to divert before you even have contact with the system. And so what I'll be talking about today is some of the examples that we've done in New York City, and then what the Center for Court Innovation has been able to do on an international scale with some of these examples. And so bringing things like risk need assessments to a place like Guatemala, or bringing some of the ideas that we have in treatment courts to a place like Mexico. And so talking a little bit about that and some of the lessons we've learned in that process.
So following up on John and Brent's comments and then putting it into an international application, especially with regards to U.S. foreign assistance, I want to leave you with two takeaways. The first takeaway on international development programs as they relate to rule of law is please do not assume that the best practices of the U.S. model apply in foreign countries, and particularly the assumption of resources exist in that foreign country to do diversion programs, to do alternative sentencing. So that's a really important thing to understand in terms of trying to export the U.S. model is that these countries don't necessarily have the resources to implement them. And if they do, you need to be very creative in terms of low-cost ways, because most of the countries don't provide the support to the justice sector through their national budgets. It's really important because I've seen too many cases, not only in Latin America, but globally, where a US donor thinks we can implement a new criminal procedure code, and they don't think about the implementation phase of it, that it could take 10 years to do it. And funding cycles don't allow that with the US donors, either with US aid programs or state programs. Talking about the area that I have worked definitely the most, and actually want to acknowledge who I consider two godparents of USG programming in rule of law in Latin America, Ambassador Michaels and Lynn, who were my mentors as I started in this business almost 20 years ago, and who really did a ton of work in Latin America and continue to do it. This is not a new idea of trying to import U.S. models to Latin America. It started in the late 1960s with Stanford University Law School doing law and administration projects, and USAID was definitely in the forefront from the late 60s until the 2000s in terms of doing various generation of rule of law programs. And it got very, very busy in the 1980s as a result of the civil wars that were happening in Latin America, and where Ambassador Michael was working in Guatemala and then came to work at aid. And so there's been successive generation of rule of law efforts, particularly in institutional and capacity building, particularly in the criminal justice sector with attorney general's offices, with the courts and the like. And then we get to the 2000s and we start seeing the State Department getting more involved in justice sector reform work, particularly state INL because of their mandate. And so now we have two leading foreign assistance authorities, both state and INL, doing justice sector work in the area. To be candid, a lot of the times aid and state do not talk to each other. We've been seeing duplicative programs or basically vying for the same opportunities. And in particularly, there has been in recent years a push on alternative sentencing or pretrial detention services in order to address the pretrial detention rates in Latin America, which is a contributing factor to rising prison populations. Each country embassy should have a working team to avoid duplication of efforts. However, reality is they continue to duplicate efforts. The left hand sometimes doesn't know what the right hand is doing. But with all that being said, one thing that I do feel, and maybe it's because I'm still a recovering lawyer after so many years, is that when these US models, particularly the legal codes, were or some of the traditions were brought into Latin America, it was not a wholesale adoption of the US criminal code in Latin America. And there have been Latin American jurists who've been heavily involved in the efforts on criminal justice reform and have contributed to those efforts. There have been some best practices that have been exported, particularly plea bargaining, which I think in some countries in Latin America have been successful, particularly in Colombia. But there have been statistics from 2007 or 8 to 2014 where plea bargaining, even in Colombia, when they first introduced it, it was 90% used in some of the criminal chambers, and then by 2014 it had been reduced to about 10% use due to 8 amendment changes to the criminal procedure code during that time period. So where it was a once very successfully used mechanism that was exported to the United States because of political reasons, got reduced to a 10% usage. And I'm not sure currently how it's done now. So I think it's wonderful to take some of the aspects of the U.S. model, but you definitely need to be careful in the application of that country, not only its legal tradition, but also what the codes permit. And the last thing I want to say is in recent years, there has been a significant push for citizen security programming. And a couple of the implementers, I believe it was EAI, I can't remember, has written a recent paper what the linkages are between citizen security and rule of law. And the way I like to try and explain that is if you have a coin and there's two sides of the coin. I see citizen security programs being really interlinked with rule of law because it's the front side of the coin where we're trying to do crime and violence prevention. And then unfortunately, if that youth does enter into the criminal justice system, we go onto the other side of the coin where rule of law and the justice sector. And they are interlinked, and I think one of the things the donors really need to do a better job is interlink the two sets of program and not silo them as separate programs.
Thanks. I have a couple of things I want to ask you about that. I'll just say briefly, in my own experience is very different as a researcher and evaluator. I think one of the things that we're starting to do well is, in the US anyways, is to start evaluating programs and build a pipeline of programs that we know work in a variety of contexts. You know, Brent mentioned that there are 51 sovereign systems that that implement justice, and they all do it a little bit differently. And so when you know a program or an intervention or a practice works in one place, it's not guaranteed to work elsewhere. There are context-specific issues that really have an impact. And so I think we as an evaluation, research and evaluation field have started to learn how to identify best practices that can be replicated and implemented elsewhere. And so I do think that's something that we've started to do well. I think there's a lot more work that needs to be done. And certainly, we've got some lessons learned in terms of how to implement these programs, but we've also started to learn a little bit better how to collect data to understand outcomes, and we still have a long way to go. But I think the justice system, with all these different data, each of these systems comes with multiple different data collection systems, and we haven't understood up until very recently what the wholesale outcomes of different kinds of policy-making decisions, in sentencing and prosecution and corrections, what the impact of those have been. We've just been experimenting for many decades, and I think we're finally learning to test these experiments in the US, and that's certainly something that has application elsewhere, I would hope anyway. But I wanted to ask you, I'm going to go off script a little bit here, because I think something that you said really resonated with me is the tension between citizen security programs and implementation of justice. And what are your thoughts on kind of a pendulum swing back and forth between those two priorities? It seems to me like when we go very far in the direction of paying attention, strong attention to public safety and citizen security is often times when we get into these situations where we're making a lot of policy decisions that have consequences for over-incarceration, that are retributive, that are, do result in over-incarceration or over-policing. What are your thoughts on how we might do that a little bit better? And I'll ask you first, Jenny, and then I'm sure that everyone else has some thoughts about this too.
I wish you'd asked me that question a year ago, before the more recent events on funding for the Northern Triangle, where the biggest amount of work has been done in terms of citizen security and rule of law program, and I'm not really clear with the funding situation right now where the future direction of that programming is going. Maybe we'll see a test case of it in Colombia in the future, but I think the big point is I would recommend to the donors that these programs work hand in hand with one another and not be siloed programs. So I'll mention a country, and I'll say country X in Northern Triangle did the two programs which were being implemented by two different implementers, the citizen security and the rule of law. They did work in tandem together, especially when there was a congressional visitation or visit coming out, a CODEL was coming out in terms of presenting the information to the congressional officials. But they're really, because of the deliverables of the contract, they were really working in as siloed programs, and I think the programs in the future need to be more integrated, because the justice system, yes, you want to protect the rights of the accused and make sure that they're afforded all their due process rights, but I think part of the game is that you've got to have that preventative measure, especially, Latin America is not experiencing the youth bulge of the Middle East. but I think there's also application, in other parts of the world, is we really don't want to see these youth get into the criminal justice system in the first place. So if we don't have programs that are dealing with these preventative measures, we're losing the battle before we've even started. And I think the success of the U.S. models, particularly on diversion at pretrial detention opportunities, has to be in that preventative end of the spectrum before we get into the actual cases. And we also need to train, even though judges, prosecutors, and defense attorneys are in the rule of law spectrum for USG programming, they need to be made aware of all of these preventative measures. And then also, the donors need to be aware whether the codes in these countries even permit to have these preventative measures being ordered by, that a judge can actually utilize as part of his toolkit.
Mm-hmm.
Yeah, one of the things you're mentioning, Jenny, is resonating with me, and it's, let's take the idea of diversion for pretrial services and exporting that internationally. I think we also have to kind of take a look inside our country and figure out, well, what are the levels of pretrial services, and what does that look like? And so to give you an example, in some states or jurisdictions, many folks may have to pay for their own electronic monitoring, for example. In other states or jurisdictions, it could be law enforcement that's doing that. In New York City, for example, it is a team of social workers that's providing that. And so I think we also need to take a look at take stock of what we have, what's working, and evaluate our program before we start kind of sending these ideas out, because what inevitably we may create is a situation where, yeah, sure, it looks good on paper and it sounds like it'll work because it's pretrial diversion and we want to divert as many cases, but now we've kind of created this other system where if you can't pay, I'm going to violate you, and that may mean that you have to go to jail. And so essentially we've just created another disadvantageous system where if you don't have money, you can't access justice. And so I think part of what we are trying to do at the Center for Court Innovation is take a look at these different models and see what are best practices within these spaces. We're talking about youth building, we're talking about community engagement. Well, what does that look like from a youth perspective? I'm not a 15-year-old kid that lives in Brownsville or Red Hook, and so I don't understand what the needs are. And so we need to go in there and do a needs assessment of that neighborhood. We need to speak to the youth and figure out what's going on. And so I caution that we take stock of what it is that we have here and the levels at which we are exporting these things, because we haven't rigorously evaluated all of our programming on the diversion side.
I have a couple of observations. Number one is you have to be aware of the age crime curve in any kind of criminal justice policy making. And it's undisputed, and this is true in every country, the crime is committed mostly by people who are in their late teens to their early 20s. I mean, it goes like that. It always has gone like that. It always will go like that. And so when you have a change in your policy to crack down on people, which we've done, for the last 40 or 50 years, and you treat 18 to 25-year-olds exactly the same as you treat 26-year-olds and above, it's going to be a disaster. Because once they're in the system, especially when they're sent to prison, and it's crime school, it is crime school. Who are we kidding, right? I mean, they have some decent programs in certain prisons, but very few people go to prison and get out better than they were before they went, or at least they get mixed baggage. So you've got to have a different policy for 18 to 25-year-olds. The brain science shows this. The Supreme Court of the United States has recognized this in some other contexts, that people who are 18 to 25 are different from people who are 26 and older. It's a brain matter. It's not just a moral judgment. So that's number one. Number two, you've got to think about your penalties differently than you think about them. We have this same standardized penalty scheme. Lower people get fines, probation. More serious people get incarceration. And don't get me wrong, I'm not an abolitionist for incarceration. There are certain people who absolutely need to be incarcerated, and for long periods of time, because they are dangerous people who are going to recidivate. But that's not true of most people. What happens is we get people early into the system and we make them likely to recidivate and to become dangerous. So you have to completely back off, and you've got to incorporate some aspects of the program that you're talking about, where you have this one-stop shop for social services. People who screw up in the criminal justice system, when they're given a chance to get out on probation or supervised release or parole, they screw up because they don't have transportation, they don't have jobs, they don't have stable housing, they don't have mentors in their communities. And when it's a cookie cutter program where every defendant is treated the same way, and has the same expectations, and we give them fines and bail amounts off of a schedule, you're gonna have disparate results depending on the person's status, and you're never gonna fix it. So you've gotta question all these assumptions. And for some people, prison works. But for most people, especially when they're first offenders and they haven't done something that serious, it's a terrible idea to put them behind bars.
Thanks. So as usually happens with good discussions, we've jumped around in my pre-prepared questions, which, to be honest, is fine with me because I prefer it that way. But I wanted to go back to one of my earlier questions and start with you, John. So I know you're doing a lot of this work, as you've mentioned, in Brooklyn, but you're also doing some work in Guatemala. And I'm wondering kind of what you and your colleagues have learned about how to meet the needs of your clients while administering justice there, and whether you've kind of run into this social services gap that Jenny mentioned that we can't assume is not going to exist. It certainly exists in many places in the U.S. too, and how you've navigated that and what your reflections are.
Yeah, the one project that comes to mind is the work that we're doing in Guatemala is around implementing a risk and need assessment for youth who are coming through the different courthouses in the city, in Guatemala City. And what we've noticed is it kind of does two things. So it informs kind of the gap, but it's providing us with an opportunity to actually get a profile of who's coming through the door. I think many in the room could probably understand or would acknowledge that our risk assessments are not perfect. They have many flaws, and I think it's still kind of a new science that's kind of emerging and we're working on. But this idea that it helps us create a profile on someone coming through the door is helping us in many different ways. And it is helping us here in the States. It's helping us figure out, well, we know that the top 3 needs of the youth that are coming through are substance abuse, mental health, and employment. And so now all of a sudden we now understand what providers in the community and what things are needed in the community. But I think back to Jenny's point before is if we're not going to pull people into that conversation and we're just going to work in a silo, then that's just going to be data that lives with us and information that lives with us that we can't do anything about. And so at the moment we are seeing in places like Guatemala that there is a huge gap in services. But at a minimum, I think what we're able to do now is articulate exactly what is needed. And I think that's been because of our ability to use a need-based assessment and figure out, well, these are the needs that are of the folks that are coming through. This is what the profile looks like. And now maybe we understand how to respond to some of the recidivism that we're seeing and the clients that are coming through the door. So I think part of it is understanding who's coming through your doors and how to respond to that and engaging the rest of the community in that conversation.
So I have a follow-up question to you, which is how is the government of Guatemala receiving this information, and are they actually applying it?
I mean, that's the part that remains to be seen. On the ground, we've implemented the risk and need assessment. It is being used at the moment. We are now working with the different multidisciplinary teams at the courthouses to figure out how they can respond. I think at this point is, we've kind of given the information, and we're hoping that the government is now coming to the table to acknowledge, well, you did a community mapping exercise and you figured out that there's no one providing substance abuse services, for example. One, that is accessible for folks because it's not free. And 2, even if it were accessible for folks, it's got 5 slots a month and you're telling us that you've got 12 to 17-year-olds, you've got over 100 people monthly that need this service. And so I think that's the information that we're getting to the government. I think that's where we have to break the silo and make sure that we can have that conversation. But I think that is often the challenge for us as kind of helping implement some of these tools is we can't necessarily go further than that. And the hope is that if we've created a team of folks or a steering committee of folks that are invested in doing this, that there will be a response to that.
Any thoughts on that, Brent? I think a couple of things that I think you're interested in came up in that discussion there, which is, or at least reminded me of some points that you've made before about also making sure that the services that you provide are culturally appropriate and making sure that that the goals of if it's rule of law programming or other programming are aligned with the goals of the community and that everybody agrees what justice should look like. Any thoughts?
That gets to a 35,000-foot view of criminal justice, which is what's the purpose of it? And I think most countries have articulated very similar purposes, from China to Islamic countries to Western countries. There are 4 main purposes of punishment we all know. It's retribution, deterrence, incapacitation, and rehabilitation. And we tick those off pretty easily, but we don't ever think about how they work, and they conflict with each other at times. I think any criminal justice policymaker needs to articulate that and make a decision about what it is they're planning on implementing. You can't say I'm for both retribution and rehabilitation. That doesn't work. You got to pick one. And maybe for certain people, they've hit the point, they keep offending after getting these chances, they need to be incarcerated. But less so, I think, for retribution, more so for incapacitation. But that's part of it, is to start with first principles and let data inform those first principles. Do these programs, if your goal is to rehabilitate and incapacitate more than it is to be retributive, look at your data. What is it telling you about how your programs currently work? I used to say at the commission, any time that the commission makes a policy decision, and this is also true of a legislative body, and it should also be true of prosecutorial decision-making at the policy level, take out your little Miranda card, but instead of having the Miranda warnings, have the 4 purposes of punishment, and ask yourself, what are we doing in terms of how what's informing our decision? Don't just do it as a matter of instinct, because instinct in criminal justice tends to go back to retribution. And I would encourage people to fight that instinct.
So we've talked a little bit too about risk need assessment and its positive uses, and the way that it can help us, do many of the things that we've talked about. Align services to needs, make sure that we are, for lack of a better word, triaging our resources, applying our resources in the correct places. Diverting people who don't necessarily need to be incarcerated, but there's also, sometimes some issues in implementing risk assessment in particular, but sometimes risk need assessment. I know in my own work, we do a lot with community supervision. Most of the data collected has to do with risk and need level of people who are under supervision, and whether those needs are being met and whether those risks are really predictive of actual recidivism. And there's been, I think, a pretty robust discussion about the risks, if you will, of risk need assessment. Do any of you have any reflections on how we can better implement risk need assessment while taking these lessons that we've learned and really applying better systems, better programs of assessment?
I think the biggest criticism, there are 2 main criticisms of actuarial risk assessments. The first one is transparency, especially the ones that are proprietary. No one knows what the formula is. So that's a kind of a procedural issue. Mm-hmm. The substantive issue is lots of these risk assessments, both the proprietary ones and the ones that are developed by governments or private or nonprofits. They consider some pretty offensive factors. I'll give you a great example. The one that is used in the federal system that I'm most familiar with, they use the PITRA and the PICRA. PITRA is pretrial risk assessment, PICRA is post-conviction risk assessment. The PITRA, and it was designed with good intentions, but it considers factors not just such as your age and your criminal history, but do you own a home, rent a home, or neither? Have you worked in the last 24 months or 12 months? Do you have a significant other? Do you pay child? Do you support your children? Factors that are heavily correlated with race and class. And I'm not categorically opposed to risk assessment. I think if you're very careful and design it, it's better than just having a clinical judgment by a probation officer or a prison official or a judge for whatever purpose it's being used for. But be very, for the rest of the world looking at the United States' experience in risk assessments, be very careful in the instruments you choose and know what you're getting. And don't just buy one off the shelf and pay the crazy amount of money for it to begin with. Criminal history is a factor that every risk assessment uses, but you got to be very careful there as well, because a lot of criminal history scores bake in racism and classism, because we know that cops, are more likely to pick up people of color. Who are we kidding? Of course we know that. And if you have an instrument that looks at, for instance, arrests as opposed to convictions, you have just dramatically skewed it. So be very cautious in which risk assessment instrument you choose.
Brent, you said something that's really interesting, and I think part of the reason why we at the Center for Court Innovation are using risk need assessments, as you mentioned, judges, prosecutors or different court actors making clinical decisions, and part of the problem is that they're not clinicians. They don't understand someone's need at the point of arraignment. And so, one example that we have in New York City is the risk assessment that's used at the pretrial phase to determine how likely it is that someone will commit another felony. So it's a risk of felony reoffense tool. We don't take into account some of the more kind of egregious examples that you gave, but we are using New York City data to help inform what are some of the things that would matter in our context, right? And so I think that's probably the first step, is if you have a place that has good data, is look at that and figure out, well, if someone is convicted of a misdemeanor in the last 5 years, maybe that does sound important, but what is the data telling us? How often is that person recidivating? And so in New York City, for example, it's telling us that there isn't a huge impact on the recidivism number after 1 year. And so we're only taking misdemeanors into account for the first year. We're looking at felonies as another example. And so when we're looking at that, we're looking at the recidivism data. We're noticing in this risk assessment that we use on the pretrial phase that anything over 8 years of a felony conviction doesn't really impact your recidivism rate that high. And so looking at your data and informing it. What we can account for, and I think this is a very important example, is some of the over-policed neighborhoods, the black and brown youth that are being targeted in different parts of the city by policing structures or the different structures that exist within these neighborhoods and within our city. And so at that point, I encourage folks to be bold if you have that space. We are also taking age into account. Brent talked a little bit about that curve, and so we know that 16 to 19-year-olds are just going to commit more crimes than someone who's 50. And so what ends up happening is you have a youth that comes from a specific neighborhood that's overly policed, that looks a certain way. All of a sudden, it's likely that they will have more contact with the police system. And so when we use that risk assessment on that individual, of course they're going to come out high risk because they live in a certain neighborhood. So what we've tried to do in a place like New York City is to account for that. And so we've created a program for 16 to 19-year-olds who are too high risk on that risk tool to try to divert them in a different way. And so if that is spitting back, too high risk, you can't work with them, we can. If you're from 16 to 19, it's just a little bit more of an intensive program. We've done that for about a year. Over 250 youth have been serviced. It's 250 youth that weren't detained pre-trial. And we've got a no felony rearrest rate of hovering around 96%. There was 4% that were arrested on violent felony charges, but I think that is a huge win when we're talking about 200 kids that didn't end up in cages. And so from our perspective, it's very important to make sure that we can be bold when we have the space and the support to do that. And at the moment, because crime is down in the United States, also in New York City, it is the perfect opportunity to be bold and try different things. And that's how we're able to mitigate some of the stuff that you've mentioned.
Follow up on risk assessment. For purposes, it's used for various purposes. It's used for bail decisions. It's used by corrections officials in the implementation of the conditions of supervision, but it's increasingly being used for sentencing purposes, both the in-out decision and the amount of time you get decision. So here's a cautionary thing about risk assessments for sentencing. A, it's new, and we don't have a lot of empirical data on it. But B, this is common sense. If you're considering using a risk assessment for sentencing purposes, don't use one that was designed for something else, because it's not going to inform the decision about sentencing. What we need to do is develop a risk assessment instrument for sentencing that says, okay, if you give this guy meaningful diversion or meaningful probation with services or whatever, what are the odds they're going to recidivate? Versus if you give this guy prison, what are the odds you're going to recidivate? In other words, a sentencing risk assessment needs to factor in variables of the type of dosage you get, the dosage response rate. So it needs to factor in the type of penalty that's given. Don't use a bail risk assessment for sentencing. Don't use a supervision risk assessment for sentencing.
I just want to quickly add so we can go to some other topics. I think the biggest challenge for risk assessments in an international context is going back to one of my themes I want to leave the group with, and that is available resources in the country. So let's use Guatemala since we've spoken about it. 10% of the country is covered by state resources like, the Attorney General's office. So 90% of the country doesn't have necessarily state presence. So when you're doing risk assessments and you're you've got someone coming from the Department of San Marcos, from a very small village, and you're trying to do the risk assessment, things that you will have to encounter are language issues. Is this, are they speaking one of the indigenous languages? And when we compare it to New York City, where there's the facilitation of translators, either voluntary or paid, that doesn't necessarily exist. So we have to come back to context and resources in an international context, especially when there is lack of state presence.
Yeah, I think what's running through all of the topics we've talked about so far is goals, context, and resources, and I think that continues to be true in global settings. It certainly is. That there's so much wide variation in U.S. contexts as well. That I think some of the same issues that you mentioned, maybe perhaps not always the language issues, but sometimes certainly the resource issues. When we are assessing people's needs, there is an assumption that we'll be able to meet those needs, and that's certainly not always true. And so if you are identifying someone's needs and you believe that those needs are linked to recidivism, rehabilitation, reincarceration, and you're not meeting them, then you're really not achieving the basic goals of risk need assessment. So then you have to question why you're doing it in the first place, certainly if you're paying for it.
Just if I can comment on that, I guess the question there is, do we have to meet the need completely? And so, there's a question here of legal leverage and what a case is worth. And so, this happens all the time for us when providing a social service. When we use the need, we often realize that the risk doesn't necessarily equate that need. And so what we hear often from prosecutors or district attorneys is, well, you said this person has a mental health issue. How much time do you need to help them? We need to know how much time is this case worth for you, right? And so I don't think they're related, but I don't think that we can always kind of walk through the door and say, we figured out what your need, we can kind of solve all of that. I think that's where the community comes into play. And so the idea here is to make sure that we're saying, we're going to help meet this need to help dispose of this case through an alternative to detention, alternative to incarceration mandate. But it's also on us as providers to connect you to community sites or community members that can help you after your case is done. We recognize, at least here in the States, you're probably not coming to a criminal courthouse for services if you don't have a case. And so why would we then say, well, we're going to give you a year worth of programming when you were charged with fare beating, you jumped the turnstile, but maybe you do have serious mental health issues. And so the role from us is to be a little bit of a matchmaker for the community so that maybe you do understand that these resources do exist or where they are in your community so you can access them afterwards.
That's a great point. I think we're taking questions now in about 10 minutes. Yeah.
Can you hear me from here?
Sure.
Okay. I'm Jim Michael. I've been dealing with this subject for many years. And I had one comment and a question, if I may. The comment is, I was a little bothered by the notion of exporting.
Can you talk into this?
Okay, sure.
Thank you.
Okay, I was a little concerned by the notion of exporting U.S. models. Just for history, and Lynn Hammergan remembers this, but the revised accusatory model for criminal procedure in Latin America began in Cordoba, Argentina, not something that came from the United States. And a couple of Argentine professors, Meyer and Binder, sold the idea, promoted it throughout the hemisphere. When they came to us, at first we were skeptical. And we said, well, this sounds like the law isn't being implemented, so let's change the law. That sounded too facile. But the demand was there in the region for reform, and we wound up supporting it. And as we got into implementing this, and more of the people who were sent to implement were former prosecutors, it took on a certain amount of that experience. But I guess my point is that justice systems are not starting from scratch. They all exist, they all have history, they all have culture that you're working with, and you can't just plug in something. That it has to be, what can we learn from each other, and what might be adapted, not exported, but adapted in ways that are consistent with the culture and the history of that country that will fit with that system. So I just wanted to put that context on it as a comment. My question has to do with diversion. I just came back from an Islamic country where, talking to the police and the prosecutors and the judges, the biggest component of volume in the criminal justice system, minor drug cases, youthful offenders. Does this sound familiar? And the biggest concern that they have is radicalization and extreme violence. To me, there was a connection, but they didn't act on that connection right now, and so you have a lot of young people in jail feeling aggrieved and exposed to some radical folks. That sounds like trouble. I wonder if you folks have some thought based on experience in the U.S. with diversion and what you're doing in Guatemala that might be relevant to our thinking about the international cooperation in terms of increasing citizen security by diminishing the risks of radicalization and violent extremism from these aggrieved youth sitting in the jails.
I think your point is excellent and absolutely correct, and it's not just in Islamic countries where we're seeing this. France is a perfect example of what's happening. So they don't publish France intentionally holds back on its data about race of its offenders, but very reliable estimates are at least 40%, as many as 70% of the people in prison in France are North African immigrants from the suburbs of the big cities. So it's not just the United States. We have 40% of our incarcerated population are black men, and France, and we have 6% of our population is black men. So, and we know that the moment you put a young person in an adult prison, they're done. They're exposed to whether it's radicalization of Islamic beliefs or it's becoming a drug dealer or whatever. It's just a huge mistake. And so what I said earlier is absolutely it's a mistake to put anybody who is under the age of 26 in a facility with much older people. That's a simple solution. It's not to say you shouldn't incarcerate some people between 18 and 25 who've done something really horrible or who keep doing it, but don't put them with adults because that's crime school or radicalization school. So that's one of the very first things that should happen, in my opinion. Every single country should treat people 18 to 25 differently.
One thought is also, how we view the youth that are involved in the system, right? And so one thing that we've noticed in Guatemala is that, and we've noticed in New York City as well, and which I think speaks more to the issue, is that there is a public misunderstanding of what someone who has a substance abuse issue actually needs. And so I think we're talking about education campaigns where we are reducing the stigma of someone having a substance abuse issue because of that issue, having contact with law enforcement, and we think that that criminal justice system is the response to that substance abuse issue. And so I think an education campaign around what is actually needed and what these youth are going through, rather than having a conversation with, well, they're in jail, what do we do with them? I think we need to start a little bit earlier in that process and have an honest conversation around why are they in jail and what do they actually need and how can we provide that before they have that contact with law enforcement.
Thank you. And so my name is Ariana Cepesi-Colmenares. I work at Chemonics. I'm part of the LAC team. And I actually wanted to build a little bit on what was just discussed, CVE, so counter-violent extremism. I focus specifically on citizen security because that's what we really see in Latin America. And I thought your comments, Jenny, about rule of law and citizen security and the need to bridge the two were very relevant. But as we think about citizen security in a sort of more worldwide, broader sense, and we start incorporating CVE considerations, what is your take on what donors and implementers need to do in order to not only bridge the gap between citizen security and rule of law, but also bridge the gap between citizen security, CVE, and rule of law? If you can comment on that a little bit. Thank you.
So I've only seen one instance of bridging that gap between citizen security, a CVE, and less so on rule of law, and that was with my prior employer, Creative Associates, who had a very small, it was with state with, it's not, I still call it MEPI, whatever the Middle East group is over there, where they try to apply, or Creative for about 18 months was trying to apply citizen security, the creative model of citizen security and its public health approach primarily through primary, I think it was through primary intervention and the counseling services later in Tunisia. And it was a very small grant, and the success rate in terms of trying to prevent any type of recidivism was pretty high. The problem was that it's very costly. And again, going back to the theme of resources, and state at the time said we would love to continue the program, but because the sample pool was 100 youth individuals, state wanted it in a grander scale. And that, I think, is the biggest challenge for seeing a bridge between citizen security, CVE, and some type of rule of law programming, is the recommended interventions from the implementers is very, very costly because it's using primarily a US-based model. And I'm not sure what the recommendation is to make it cheaper and more palatable to the US donor.
Hi, my name is Mary Greer. I'm the Senior Criminal Law Advisor at the ABA Rule of Law Initiative, and I want to thank our organizers and our hosts and the panelists. We're working on, well, criminal justice generally, but specifically the alternative dispositions in criminal cases, and probably, well, a lot of our countries in the Europe and Eurasia region that have shifted toward an adversarial system, but specifically currently, I can think of Armenia, Libya, and Bahrain. And I'd love your feedback on one of, I think, my observations in terms of the challenges of implementing the alternatives is, you know, it's not only a situation where judges feel like they're kind of taking the hit for the use of considering alternatives, whether it's a request for putting someone out instead of incarcerating at the early stages. But, you know, it's sometimes it's the appearance of corruption or influence, undue influence, if not the presumption of corruption when judges or prosecutors do something different than what they're used to doing when they're implementing alternatives. And I remember a conversation with the Attorney General I had in one of those countries when we were talking to him about implementing alternatives. And he and his staff, it was back to your observation, Brett, it wasn't in their world to think of anything but filing every criminal charge and asking for the maximum disposition. It just was not in their world. And, you know, since then, they've actually been implementing alternatives. But I wonder about your observations and the challenges with the attempts at members of the judiciary, including prosecutors, to be better in terms of their independence, but also be more creative in terms of solutions in a criminal justice context. And the other question I would have, we're working a fair amount in CVE and in counterterrorism programs. Any observations you would have in terms of the use of risk assessments in specific substantive areas like CVE or counterterrorism, whether at the earlier stages or at the dispositional stages?
Let me start with your first question, which is the instinct of prosecutors, and this is true everywhere, inquisitorial or adversarial, procurators in the inquisitorial system. It's their instinct to, you know, I mean, they want to exist, right? They want to feel like they're there for a reason, and I think the instinct is to hit them hard and, you know, go for the max, and that's a cultural thing. And one of the things also to keep in mind about any country is their judicial branch, if they have separation of powers, is their judicial branch separate from their executive branch? Some of the countries, everybody's a magistrate, right? The prosecutors are magistrates, the investigating judges are magistrates, the trial judges, they have penitentiary judges in a lot of these countries, right? So first thing to do is to separate, is the prosecutor separate and apart from the judicial branch? If the prosecutor, and also the other thing to keep in mind is there one Ministry of Justice that is in charge of everything? That's one of the biggest mistakes we make in the United States, is that we separate the implementation of and the budgets for police and prosecutors, prisons, and correctional officials outside of the prison and courts. So in other words, there's no consideration by a prosecutor of the budget for the prison. There's no consideration by the prosecutor of the budget for the probation officers or parole officers or who are going to be supervising people. they should all be considering this. It's a zero-sum game in terms of the money we have. But to your point, in terms of the prosecutors, whether they're part of the judicial system or not, there still is this instinct, and that's going to require some higher-level policymakers saying, we got to change that. We got to inculcate these young prosecutors and tell them, sure, there are certain people who need to be incarcerated, absolutely, but don't make that your instinct. So one thing to do is something that we did in theory in the federal system, but it failed, which is there's a provision of the 1984 Sentencing Reform Act that says a first-time offender for a non-serious offense is presumed to not get incarceration. That statute's rarely ever been followed, partly because in the federal system they tend to bring pretty serious charges compared to the state systems. But if you actually enacted a statute where there is a rebuttable presumption for non-incarceration for a person who's never committed an offense before and only has committed hadn't committed a serious offense that brings them to court, there should be a rebuttable presumption. That helps change the culture. So that's one suggestion I would make. Does anybody else want to comment on that one?
Yeah, what's coming to mind, and I think Brent's talking about kind of a systems change. You mentioned the word cultural. I think part of what we also should talk about is what can you do right now? And so is there a judge that is willing to do this? I think in these situations, what we have found is we just need some data. We need something to kind of show folks that there is a different way to do things within the way that things are currently constructed. And so if you find that one judge or that one prosecutor that is willing to pilot something on a small level, try something for a year, see what those outcomes are, and start to bring that scale a little bit bigger as time goes on while you're doing some of the system and cultural change work. I think the model here in the US is we didn't dig this mass incarceration, we didn't dig ourselves into this mass incarceration hole overnight, and I don't think we're going to dig ourselves out of it overnight. And so I think part of what's really important is we can work on both in a parallel process, right? Is there's this system and cultural change, but what can we achieve right now on a small scale on a pilot that maybe then means we don't have to talk about importing or adapting US ideas, but now we've done something locally homegrown to this country, and you can now start to scale this on a much bigger level.
And I'd like to build on John's comment. I think the place to do that pilot is in the judicial school or in the prosecutorial school in the country. To see who those agents of change can be, to apply this type of pilot so that it can have then later a multiplier effect. But as you well know, Mary, a lot of these countries have a judicial school and they don't necessarily have a prosecutorial school. And then there's the roles for each justice sector actor.
I think it's a really good point. So we don't have a professional judiciary in the United States. Most countries do, or at least most of our peer countries do. It's a civil service. And that's the best place to inculcate somebody, not after they're a 50-year-old practitioner who becomes a judge, and that's not the place to do it. Elected judges, the rest of the world do not elect your judges popularly.
But I think what all of you have said, and I think the example that comes to mind from what all of you have said is problem-solving courts, and that was one judge and one change agent who was able to, do a demonstration. I think you were around during that time in Miami, right? Were you?
A little before my
A little
time.
before that time.
A few years before my time, but I'm certainly aware of it.
Yeah, and had absolutely created a movement that thinking of justice differently. Thinking of it as a team problem-solving effort. That, there's been a lot of trial and error involved in it, certainly, but has definitely changed the culture, I think, around how cases are, what the disposition of cases is even, but how cases are thought of in certain types of courts. And certainly, we were talking about the Brooklyn Mental Health Court earlier. There are a lot of examples of this working really well, I think, where, we would have liked to see certainly more data and evaluation and information on what components of that worked well and what didn't earlier on in the process of the replication of that. But I think it's a really strong example of just a handful of people making a huge systems level difference. I don't know what your thoughts are on that.
I love the idea in theory of a problem-solving court. But I think there are ways of achieving that perhaps in a more evidence-based way that don't necessarily involve the problem-solving court model that we see widely used. I think the services that your agency provides can be done without necessarily having the judge participate when perhaps people who are more professionally trained to do these things should participate. Don't get me wrong, there are very good-hearted judges out there, federal and state judges all over the country, who take their robes off, get off the bench, hug the defendants, best intentions, but we don't really have a lot of data about whether those kind of heavily judge-involved programs work. None of that's to say that you should not divert and that you should not give social services. I just don't know that the judge involvement part has been shown to work.
Yeah, that I agree. I think that there has to be a lot more research on what those interactions are, what produces success, what produces, there's since those kinds of courts came into existence, there have been some objections and some concerns about net widening, and
A lot of net widening.
certainly, I think there's strong evidence to at least suggest that net widening has happened as a result of them, and they certainly happened, in concert with a lot of the hole that we've dug ourselves into with mass incarceration. But I do think it is still a good example of a change, whether you agree with the change or not, that a relatively small number of system-level actors can
I don't think
make
a
change.
diversion necessarily is something that a court has to do. You can have cops who do diversion. You can have prosecutors
Certainly,
who do
yeah.
diversion where a judge never isn't even involved.
And I think we're seeing that more and more with the crisis intervention model of, police diverting, police intervening, and making, rather than bringing someone to a jail, bringing them to an emergency department, bringing them to a community mental health center. The problem goes back to the resources and whether there are adequate resources in the community to support that and maintain public safety while you are diverting people away from, and that always remains the community concern too.
And a flip side of the coin is, obviously at the front end, diverting is important, but if someone has maintained a crime-free life over a certain period of time, there should be some expungement, easily available expungement options. But as we all know, there are people who don't get apartments today because they were arrested 40 years ago. And to the degree the internet's taken off, the rest of the world just like it is here, that's going to hurt people in other countries as well when somebody sees they have an arrest record, but they haven't done anything for 30 years.
Yeah, Lynn Hammergren. I mean, this is so interesting. I can't figure out which thread to pick on. I guess one comment. I mean, Jim already made a comment about this not being a U.S. export to start, although I'd certainly like to get U.S. prosecutors out of the process because they're really trying to push a model which doesn't match the codes. The codes are a mix of adversarial, or as they call it, they're accusatorial, but also a lot of European influence. And to pick up on that, I mean, we're in the U.S., so we got to talk about our model, but there are interesting models from elsewhere. Actually, there are European countries that offer much better subsidized defense to defendants than we do in this country, to the point where the Great Britain has had to reduce the budget for it because they were out of pocket. But I guess on one of the things that surprises me, and maybe you can comment more on this, well, there are two things. One, I think the link that Jenny talked about, and I'd like some comments from her on this, between citizen security and rule of law is police, which in Latin America, they're terrible. And so you're not going to have them doing good diversion, but they're terrible because they're underpaid, they're not protected, and they haven't been involved in the new codes because of some notion in Latin America that prosecutors investigate, not police, which is bad. Now on diversion, well, the prosecutors, I guess most of them are happy about that, except Lindquist wasn't, which amazed me. But on diversion, Guatemala, it may be working, but pretrial services in Mexico have come along with the notion that this works in the US, there's a magic formula, we will use it, and there is neither pushed by the donors nor realized by those who are involved, there is no attempt to analyze the results. We don't know whether this magic formula is working, and I interviewed several people who were applying it, and one of them finally said, I don't know why when someone gets a 5 on our chart, that person ought not to be put in pretrial detention. mean, no one knows. And I'm amazed that the donors, and in this case it's USAID, are not promoting some kind of analysis there. And then Jenny's point, though, is very true. There aren't resources. I don't really believe that only 10% of Guatemala is covered by state resources. I mean, the thing is, they
The
may
Attorney
not have a
General's office.
prosecutor, but they probably have police. But the point is that they certainly don't have drug treatment. And some of these pretrial services, and this is a criticism made of the U.S., put such onerous conditions on someone for staying out of jail that they can't, 2-hour commute to check in and say, here I am. There are no drug treatment services. And in addition, there's, I remember in El Salvador years and years ago trying to talk about giving people meaningful employment. And they said, why should we give meaningful employment to a criminal? There's not enough for the ordinary people. So I guess, how do you deal with that?
Well, rehabilitation is oxymoronic and inevitable, right? If we don't rehabilitate people who've committed crime, they're only going to do it again, right? So you just have to recognize that. And of course it diverts resources from innocent people but a small percentage of people commit the majority of the crimes. And if you aren't dealing with that fact, it's just going to get worse.
Your point about supervision and supervision making it worse, I think definitely has been noted by a number of supervision agencies who are here, who are trying to do better, but still, are hamstrung in that because, going back to judges, because judges impose conditions of supervision that aren't necessarily in line with agency policies, and so then you have somebody driving, it happens here too, from rural areas, having to check in frequently. I think Center for Court Innovation, other organizations have been experimenting with that model to try to, do different things. I know certainly DOJ has tried to implement different types of, test different types of models too, like kiosk supervision or mail supervision for low-risk people, things like that. But it's again, it varies so much across the U.S. system. I'm sure elsewhere varies even more incredibly. But it is surprising that it is a point not often taken or not always taken that you are doing harm when you're imposing certain types of conditions that are very much not in line with the goals, even if your goals are retributive, even if your goals are surveillance-oriented goals, controlling goals versus correctional goals, you are still doing harm because if you are interrupting someone's ability to have a job, to have a successful family life, to be active in their community in a positive way, if you're requiring them to follow these onerous rules that really don't have a whole lot to do with committing new crimes.
The point is that these models get sent or promoted in Latin America without that caveat, and in
Yes.
other countries as well. So how do we get the donors to realize that AID was enthusiastic to the max about pretrial services in Mexico, and no one who was promoting this seemed to realize that it comes under criticism in the United States. So how do we get them to do it? I assume in Guatemala and so you're doing that and you're working with, but the problem is, and it's not just pretrial services, it's a lot of stuff that gets promoted. The donors pick it up, say, oh, this is wonderful. And it happens in civil justice as well, too.
Yes.
And somehow, whoever they hired who knows something about it never says, well, it's wonderful, but.
I think I made the comment before about taking stock of what it is that we have, what's working and what's not working through evaluation processes that we have here. If we're designing some sort of pretrial program in another country and we're helping design that, I think one of the lessons we have here is you have to have rigorous data collection and analytics of that, right? And so you can't just say we're going to do this for 3 years and see how it's going. You've got to make constant adjustments to your risk categories, to the services, how far someone lives, how often they're reporting. And then once you implement something, in theory and on paper, it may have sounded great, but in reality, you're noticing things that maybe you didn't imagine were going to happen. And so you need to constantly be in an evaluation space, but I think it starts with taking stock of what we have here in the States, what that looks like, and evaluating all of that and figuring out this is kind of the cream of the crop as far as we kind of see pretrial services, and now how can we adapt that somewhere else, but working with those governments in those countries to make sure that they understand this is an ongoing process that we have to constantly evaluate.
A social scientist should be an adjunct to any program that is funded, whether by the government or a private donor. It's foolish. It's foolish to not have somebody rigorously collect data and analyze it, and not just for a year or 2 or 3. These things are long-term.
But they hate it.
Yeah, so I think we only have time for one more question or comment. Is that right, Tiff? Okay.
I just wanted to reinforce Jenny's point about resources by the country where you're working. And that is, there are, having social scientists involved. Well, social scientists have to be paid. The social services that are necessary for a diversion program to work with the individual who's been diverted has to be paid for. And the donor relationship, the international cooperation aspect of this, has to try to work with the prospect that the local actors will pay for these things, are just supporting the creation of them and then walking away and have them fail because they weren't financed, is not doing anybody any favors.
Great. So I think we're out of time, is that right? We have 10 minutes, okay, all right, my timing is
over here.
up. Okay, all right, so we had one more, another question.
I'm curious. This has all been very enlightening, and I've enjoyed it. Our current problems in the United States with the chaos that we've been challenged with, and the guns and the murders, and people just seem to pop up and, invade schools and kill classmates and so on. What, if anything, is being done about that, or what kind of path can we take to people that might be radicalized or be open to propaganda online, exposed to propaganda online? How are we dealing with things like that in our own country?
That's a whole separate discussion.
But very concerning. I mean, it's almost a daily occurrence.
Well, you mentioned firearms. That clearly is a factor that makes us different from a lot of our peer countries. The ready availability of firearms, handguns in particular, semi-assault weapons and so forth, which is a whole different discussion. But if you were to take, if you were to do Western Europe's or Asia's firearms policies and put them here, we would see, if it could happen overnight, if we just magically get rid of firearms in the United States, or not get rid of them, but regulate them the way that they're regulated in European countries, we would see a massive change in our violent crime rate. But that's about all.
Why are they so afraid to do that?
Because we have the Second Amendment and a big lobby for that. That's a whole different.
That's sad, because so many people, young people, are being killed, or someone has this idea in their mind, I'm going to go and shoot up the school. And there are so many innocent people who are haunted by this, who are killed, in their early years before they can go on to careers and be a law-abiding citizen and do great good in our society. I mean, I know NRA is very strong, but why can't we do something? Why can't we maybe follow some of the outline that the European countries are following?
It's just a cultural thing here.
So, but I do think there's something related to what you're saying that is important for us to keep in mind as we implement policies both in the U.S. and abroad, and we're just in the infancy, I think, of this in the U.S. as well, but really integrating trauma-informed care and trauma care itself into our interventions as well. And I think, Brent, you talked a lot about recidivism and the cycle of people in and out of prisons. And one thing that happens, particularly to young people in prisons, is they come in often with a high level of trauma, and then they're re-traumatized, and they're in states of hypervigilance, and they are having a very difficult time having normal reactions to things by the time they come out of prison, and that definitely, you know, we know that
And then
contributes.
they self-medicate.
They self-medicate, and we know that that contributes to, you know, our cycle of our justice system recidivism cycle. But have you all had any experience? What are your thoughts on making sure that we're integrating trauma-informed care or trauma care itself into the programs that we model?
In my 17 years as a public defender, admittedly, I finished in 2009, so a lot's happened in these 10 years. I never heard anybody talk about that.
That's, yeah, I mean, and it's such a, you know, it's such an overwhelming issue, you know, and I think it goes back again to the resources discussion, but also the cultural discussion and the idea of having community goals for justice programs that we're delivering, and that I think there are community goals, no matter how you define trauma, of reducing trauma in communities. And why isn't the justice system anywhere a bigger player in that?
We have a system that, as I said, focuses on retribution. And when you have a retributive system, you look at all the actors, unless you're insane or something, which is the rare outlier, you look at everybody the same, and you don't consider their history. Only in our death penalty cases do we make it mandatory to consider mitigation. We don't consider mental health mitigation. We don't have mitigation specialists in most of our criminal cases. We just cookie cutter. You committed a burglary, you committed an ag robbery, you possessed X number of grams of whatever with intent to distribute, here's your sentence.
So thank you for bringing up kind of the point of trauma and the various ways that we have trauma. It is. And so I think with that, I wanted to just go back to our themes of earlier of resources, goals, and cultural relevance for programming that we implement. Ambassador, I take your point on not describing this as exporting models, and we didn't really get to this, but you know, in the reception after, maybe we can talk a little bit about too. What are some positive models that the U.S. I think it came up in the Q&A a little bit. So some positive models that we in the U.S. should be absorbing and trying to emulate ourselves, because I think what we've talked a lot about here is some things we don't do well, you know, and some lessons that we've learned, which, you know, again, was the point of the discussion. But as we wrap up, any final points that the panelists want to make briefly, and then we'll have some closing remarks.
At least in the international development context and rule of law, there's still a lot of work that needs to be done, particularly in rule of law development and in institutional and capacity building of the justice sector actors. And we're in interesting times right now, and I hope there is going to be continued support, particularly in the Northern Triangle. We've invested a lot of money since 1982. I'd like to see a return on that investment.
You know, the one point is one that we talked about before for me, but making sure that, you know, we can, if there's an opportunity to try something, however small it may be, to adapt something that we've learned here that someone may be interested in learning more about or seeing how it works in their country, is to try that, provide the resources and support, identify the folks, and then have that be the thing that builds for other folks in that country, right? And so this is kind of an adaptation of an idea from the United States, but now it's become kind of your system, your idea, and now you can kind of grow this to scale. And so I think where there is an opportunity, where there is appetite to try that, is to start small, build off of that, and include all of the system actors in that process and in that conversation. Because what we've seen is when you don't, you end up creating something that may be great, but it'll stay on the shelf because maybe the prosecutors weren't on board or maybe the defense bars weren't on board. And I think the idea is to bring everyone to the table, start small, and try to grow from there.
So instead of summarizing or focusing on a point that's previously been made, I think this has been a really helpful discussion, and one that I have never experienced in all my years of meeting international delegations when I worked at the Sentencing Commission, going to academic conferences, reading symposia. We need to have this on a much broader scale, and have people who represent the international community, the donor community, people with on the front line, lawyers, non-lawyers, judges, cops,
Researchers.
policymakers,
Social scientists.
Literally have a symposium where you get representative people from all the different parts of the world, all the different systems, because there's a lot of vocabulary here that some of us may not even be aware of. And some of us just throw out these terms, and they're just something we deal with on a regular basis. But maybe once we translate them to somebody who works as a researcher, who works in a different part of the world, or who's not a lawyer, we might learn from one another. So that would be my concluding note.
I think that's a great concluding note. And then we're going to have closing remarks from Jamilia Mizrahi from Democracy International. Thank you. See, everyone is smarter than me and Chris. We're figured out where the stairs are.
I have a problem with the book. I'm so short. Can you see me?
Wait, do you want to sit here? Here.
No,
You
it's
can sit
okay.
here. Okay.
I'll just, can you see me? At least my face. Well, thank you so much. John, you stole my comment. That was what I was going to say. Absolutely. I've never seen such a creative conversation. And I welcome to have more. I come from the social sciences. I am a political scientist by training. I work on the citizen security angle. And if you think that USAID and state don't talk, I think even within USAID, the governance and the rule of law
Don't talk to
people
one
don't
another.
talk to one another.
agree.
So this is absolutely something that we need to foster. Before I thank the panel, after I thank the panel, I also want to thank, on behalf of TI and APT, the staff here at the Center for Global Development, specifically Charlie Rong and Saul Jiba for their technical assistance. There's a lot of things going on behind the scenes that make this happen, and it has gone seamless. I'm sorry, I'm Mexican, so I make a lot of mistakes. And it's been a pleasure working with you. In terms of substantive comments, I think that you have a point about how the importance of data and the sensitivity to cultural differences. But there's one thing that, as you were all speaking, that with all the cultural differences between Latin America, I can speak more of Latin America and the US, and with all the differences, there's certain things that are very similar. First of all, both in Latin America and here, most of the crime is committed by youth. Very few people commit most of the crimes. Crimes are sticky, they are place-based, they are specifically located in certain sectors. We all know that. We all know that over-incarceration is not effective. We all know that that yields to high recidivism. We all know that there's data on that. And more importantly, I think we also know that the risk factors are very similar. Unemployment, substance abuse, family violence, especially the kids that have been subjected to violence as youth, tend to be more prone to violence. We all know that. And we also know that if you throw a child or a young people in jail, they become criminals. I just came back from Honduras, and in Honduras, when they detain a minor in the juvenile detention system, they force the youth to identify with one of the two gangs. So there's two prisons, one for Salvatrucha and one for 18. And the child has to, if it's 14, 15-year-old, they have to identify with one another, even if they are not actively part of the gang. But the minute they throw them in one of these facilities, they belong to the gang. So the system also forces them to, yields them to become criminals. So we all know that. The problem is, and this is where the social science part comes in, is that no matter how good the evidence is, and no matter how the pilots can work in the US, and no matter what we know about recidivism, we still need to work with those governments. And the problem is that, as far as I can see, is that, first of all, the mentality hasn't changed. They still have a very punitive attitude towards crime, especially youth. They don't see these criminals as victims. They see them as criminals. And as criminals, there's no redemption. There's really no redemption. There's no rehabilitation. There's no point. So they throw them in jail. They provide zero services, very little. Any rehabs offer that there is funded by the donor community or by the church, the evangelical church in particular. In a way, if the donor community was not there, these kids would have nothing. The governments don't care. That's the truth. They don't care. Even if they say the contrary, they really don't care. The community could provide services, but they are so poor, so most of the times the communities do not have any resources to provide services, even if they would be, the evidence tells us that they work, and it would actually be much more efficient than throwing them in jail. And then we also have to think of the C word, corruption. That plays an incredible amount of, that is a big player in these countries. So I'm all for evidence-based. I hope that we get to do some evaluations of these pilot projects in Latin America, and I would hope that USAID takes the data and propagates it, especially when we can demonstrate that something works, and press these governments towards adopting those models and put some money into them. So with that, I want to thank all of you, and I want to remind all of you to join us on June 18th for the final session in this series. It's going to take place at the Urban Institute, and it's called From Thinking Politically to Working Politically. Are we really doing development any differently? Which is exactly what we're talking all about here. We'll be joined by international renowned thinkers and doers who will find perspectives on how to think and work politically and lead us in small breakout discussions. So I hope to see you all there, and thank you very much for coming.
Thank you.
Thank you.
And thank you for this great discussion.